So we will just going to wait to for other attendees to log in. I will do an audio check at exactly 1 p.m. Eastern Standard Time just to make sure that everyone will be able to hear the audio. So just please stand by and we will start the presentation in a few minutes. Thank you. Hello again, everyone. Again, my name is Ron from International Trade Council. For all attendees that is currently logged in, I would like to know if you can hear me clearly. If you can hear me, can you please type in yes in the chat box just to make sure that you can hear me clearly. Thank you. Thank you so much. How about the others? Perfect. So we are going to start at exactly 1:05 p.m. Eastern Standard Time. We will just wait for other participants to log in. I will make the introduction and I will going to inform some rules about this presentation. So I'll get back to you at exactly 1:05 p.m. Let's just wait for other participants to log in. So thank you so much for responding, and I'll get back to you after a few minutes. Everyone. Good day. Again, my name is Ron from International Trade Council. So, today we will have a presentation about recovering bad debts from customers in India from Veyrah Law. It will be presented by Mr. Ajay Joseph and Aaron Mohanty. So, basically, what we will do today is we will let the presenter to discuss the slides, and then if you do have some questions, just type in your questions in the chat box, and then the presenter will going to answer your question after. And then just to inform you, once the presentation is over, we will going to send the presentation to your email, since you all guys registered for this webinar. And also, this presentation is recorded, so if you would like to get a copy, just let us know. So just to give you an idea, International Trade Council is a peak body chamber of commerce, and we are headquarters in Washington, D.C. and Brussels, Belgium. And we also have some regional offices around the world as well. So I think we can go ahead and start now. Anyway, while the presentation is ongoing, other participants can just jump in and log into the presentation. So I will give the floor now to Mr. AJ Joseph and Aaron Muhanti to start the presentation. Thank you. Go ahead, sir.
Thanks, Ron. Thank you so much. Good morning, good evening, good afternoon, ladies and gentlemen, joining us from different locations. It's a pleasure to have you. So, just to start off, I am Arun Mohanty. I will be starting off on the presentation. I also have my colleague, Mr. Ajay Joseph, with me.
Hello, everyone.
And as and when required, he will pitch in, and the Q&A session, both of us will take on together. Okay, so well, I'm assuming that the lovely audience that we have today, in you gentlemen and ladies, belong mostly to the business community who are either currently engaged in or are interested in doing business with Indian entities. Many of you may be engaged in supplying goods or services to Indian companies and may have certain outstanding trade receivables stuck due to the delinquent nature of the customers in India. Otherwise, as well, India is one of the most fast growing economies in the world. Most companies are looking out to do business with their Indian counterparts. Considering that, like, it is pertinent for you to understand the regime that is followed in India for an overseas supplier of goods and services to recover their unpaid dues. Also, to understand the necessity to stick to the laws prevailing in India and ensure recovery of your unpaid dues in a time bound and hassle free manner. Well, the Insolvency and Bankruptcy Code. Now, the Insolvency and Bankruptcy Code was enacted in 2016, a much needed legislation for India, which sets out the process and procedures of dealing with an insolvent company in a time bound manner. Most of you who are connecting with us today from separate countries may already have certain similar legislations in place in your respective countries, which provide for an efficient recovery process. Well, the Indian legislators woke up a little late, but like they say, it's never too late. And the IBC introduces certain concepts such as operational creditors, financial creditors. We'll get to all of those terminologies, and we will kind of run through the prescribed definition of these terminologies, what they mean, how are you being categorized as operational creditors. We'll get to that when we go to the relevant slides. Now, look, the underlying theme of IBC was to provide a methodology to ensure recovery of outstanding dues from delinquent customers, be it recovery by banks and financial institutions or by supplier of goods and services. Now, the IBC for the first time in India sets out a clear time-bound process to effect recovery of outstanding dues. Now, whenever one enters into a dispute or a litigation, we believe that there needs to be certain strategy in place as well to ensure that they drive the outcome of such litigation in a favorable manner. The strategies, of course, will be different under different circumstances, and each case comes with its own ifs and buts. But nonetheless, we will touch upon all of these points. We will try to run through all of the contents that we are showing you right now, and also discuss the strategic considerations which you should have in mind. Now, moving on to the next slide. What is the relevance of this webinar and for whom is it relevant? Again, assuming that most of the audience today that have connected with us are companies or entities who or work in entities who are currently engaged in doing business with their Indian counterparts, could be a safe assumption to state that there is a high likelihood that many of you have certain outstanding receivables from your Indian counterparts. Such outstanding dues have a great ability to affect your cash flows and your financial planning for your company. Now, we would like to navigate you through the methods and procedures prescribed under the IBC to recover your dues. Now, lack of efficient alternate remedies in India. Now, it's slightly unfortunate that we are still being governed by some of the age old archaic laws drafted and enacted during the British rule in India. IBC is the first of its kind. Uh, the Indian laws prevailing prior to the enactment of IBC were not helpful in recovery of dues, let alone in a time bound manner. The other processes prescribed under law could take ages to complete its cycle, and by the time the adjudication is over and a verdict is out, it may not be fruitful and your commercial objectives may never be achieved. One of the reasons that proves IBC's efficiency is the time bound resolution that is for the first time prescribed under Indian laws. Now, ever since the IBC has come into force, we have witnessed a paradigm shift in the way the companies operate. Now, simply put, the fear in Indian companies and Indian promoters against being dragged to courts for violation of IBC. Now, one such recent case, if I may touch upon at the start, is the case of Ericsson versus Reliance. Now, as most of you may be aware, Reliance is promoted, owned, and governed by one of Asia's richest family. Now, just a brief background of what happened in that case. Uh, Yes, Amanda. Hi, Amanda. IBC is Insolvency and Bankruptcy Code. Sorry if you didn't get that earlier. That's the law that we are speaking about. This was enacted in 2016, and that is the law which kind of facilitates recovery of dues under the current regime in India. I trust that's fine. Okay. So moving ahead, now like I said, Ericsson was. I'm just touching back on the Ericsson versus Reliance infertile matter. Ericsson was supplying certain goods and services to Reliance Telecom and had significant dues payable to Ericsson. They had certain out-of-court settlement talks in line with IBC and agreed to settle at about 80 million United States dollars. Now, Reliance Telecom still defaulted on making the settlement payments to Ericsson. Ericsson took shelter under the Insolvency and Bankruptcy Code and the adjudicating authorities stipulated payment timelines and ensured that Ericsson recovered its dues in a time bound manner. Considering that such major and influential companies in India are forced to kind of bend the knee to the IBC, uh, we Indian lawyers are slightly hopeful that this new regime is definitely going to help us and in turn help our clients in achieving substantial reliefs under the IBC. This is quite a welcome change for us. Now we move on to the intent and objective of IBC. Why was IBC introduced in India and what was the need of the hour? Now, of late, the Indian banking and largely the Indian economy has been badly hit by a host of financial problems, be it unpaid loans, be it the money laundering scams, be it various loans being categorized as non performing assets, and the likes of it. Now, a streamlined methodology for banks first to recover unpaid loans was the need of the hour. IBC provides for such streamlined methods to ensure that monies due and payable to banks and financial institutions are recovered in a time-bound manner. Of course, there were recovery tribunals operating in the country prior to the enactment of Insolvency and Bankruptcy Code. However, none of them provided a sincere time-bound method for recovery of money. Now, it was along with banks and financial institutions, the legislators also realized the importance for foreign suppliers like some of you who do business in India. It's becoming really a big hassle for them to do business in India and then kind of enforce the contract to recover the money. And as bad as it may sound, enforcing contracts in India could take ages. It could take you might not be claiming a substantial amount, but it still could take ages for you to recover that small amount. Now, due to lack of such methods of recovery available with the suppliers, and Indian companies and businesses have been quite casual generally as well as historically. Unfortunately, that's been the trend in India. The IBC adopted certain extreme grounds which act as a major deterrent, and it has also instilled certain sense of discipline in the Indian companies and Indian promoter as to how do they go about ensuring financial discipline in conducting their business. Now, one of the major reasons also was the World Bank issues something that's called Ease of Doing Business Index. India always ranked very poorly. Thankful to the introduction of Insolvency and Bankruptcy Code, we have taken few baby steps ahead. So we're still far away from an ideal business environment. But as I said, it's little but never too late for this as well. Moving on to the next slide. Yeah, what are the key concepts prescribed under IBC? Well, just to discuss the overview, financial debt and operational debt. Well, financial debts, so to say, are your regular debts. The debts that are owed to banks and financial institutions are categorized as financial debts. Now, under the insolvency and bankruptcy regime, it specifies that any amount which is in the nature of borrowing by one party to the other is a financial debt. And likewise, banks and financial institutions or any person who lends money to the other person is called as a financial creditor. Now, what is operational debt? Operational debt means any claim in respect of provision of goods and services. It also includes wages to be paid to employees and taxes which a company owes to the government. And likewise, persons making claims for dues payable against provision of goods and services are termed as operational creditors. So most of the audience over here, if you are in the business of providing goods and services to your Indian counterparts, you will be categorized as operational creditors if at all you take shelter under the IBC to claim all your outstanding dues. Now, default. A default is another term prescribed under the IBC, as so to say, generally means non-payment of dues by the Indian company once it's become due and payable, and the creditor claiming against the person against whom the creditor is claiming is called a corporate debtor, which could be a company or a limited liability partnership under the Insolvency and Bankruptcy Code. Now, resolution professionals. Who are resolution professionals? Basically, resolution professionals are professionals who are appointed by the adjudicating authorities to conduct the insolvency resolution process of a corporate debtor, that is a company or LLP, if at all the application of a creditor is admitted by the adjudicating authorities. Now, who are the adjudicating authorities? Are the two sets that are written at the last of your slide: the National Company Law Tribunal and the National Company Law Appellate Tribunal. Currently, there are 12 national company law tribunals in India. All of them have separate geographical demarcations and jurisdictions. Say, for example, the National Company Law Tribunal in Bombay has jurisdiction to entertain disputes under IBC for the states of Maharashtra and Goa. And there is one appellate bench operating out of New Delhi, India, which is the appellate authority and entertains all appeals coming from national company law tribunals. Now, what are the advantages of IBC over the normal court processes which were prevailing in India since time immemorial? Now, what happens is that once an interim resolution professional or a resolution professional is appointed by the tribunal to undertake the insolvency resolution process and liquidation, the board of directors and the promoter of that Indian company absolutely lose their rights to govern the company. It is then that the resolution professional steps into the shoes of the board and the promoters and manages the company until the completion of the insolvency resolution process. Now, in such situations, what happens is Indian directors and promoters are stranded helplessly, and that is the moment no such director or promoter needs to witness or wants to or likes to witness. Now, Indian promoters treat their companies like their babies, and this does not go well with them. This is the maximum deterrent, that was needed for India. This is the maximum deterrent that they could face, and by initiating an application for commencing insolvency resolution process against the Indian companies, you actually explore a lot of other options as well. They are forced to bend the knee to you. Maybe if you think of that, they might come up with settlement discussions as well. Apart from that, what is the resolution and recovery time under the IBC? As I also touched upon earlier, prior to the enforcement of IBC, India never had a law which facilitated time-bound recovery of unpaid dues. Now, it became increasingly problematic for foreign suppliers to enforce their contracts and recover dues from delinquent Indian customers. Now, under the IBC, for the first time, there's a time-bound recovery prescribed. All resolution and recovery matters under the IBC have to be dealt with and disposed of within a period of 6 months. There's also a buffer of 3 months which the tribunal may permit upon application, the extending of resolution could be done by another 3 months. So the maximum time that you're looking at could be somewhat around 6 to 9 months. And also IBC is very cost effective. We also have a slide stating that the statutory charges are really low, and the legal fees, of course, varies from one law firm to the other. It depends on whichever law firm you intend to proceed with, and basis that it could be high or low. But it's overall the statutory charges are really low, and it's really effective, cost effective process. Now, moving on to the next slide, who can file a claim under the IBC? Under the IBC, broadly, there are three entities who can file claims. The operational creditor, who's the provider of goods and services. The financial creditor, who's somebody who's lent money to the company for a fixed rate of interest. And the corporate debtor himself. The debtor, if the company themselves realize that they have a lot of outstanding debts and they are absolutely unable to repay their debts, they might opt for a voluntary liquidation, so to say. And these are the three broad entities who can file a claim under IBC. For audience who have joined us who have been in the business of providing goods and services to their Indian counterparts, just to reiterate, you fall under the category of operational creditors. Now, moving on to the next one, who is eligible to file as an operational creditor? Now, like I said, an operational creditor is somebody who's a supplier of goods and services, is entitled to file claims if there have been certain unpaid amounts against provision of certain goods and services. Now, it is vital that the unpaid amounts were due and payable at certain point in time and have been defaulted by the corporate debtor. There is a monetary threshold which the IBC prescribes. Currently, it's at Indian currency rupees 100,000, which converts approximately to USD 1500. And looking at the way the USD is moving up, rising meteorically, it could be somewhat around $1,200 to $1,300 in the next year or so. It is extremely vital that there have been no disputes raised by the corporate debtor against the provision of goods or services, its quality, the invoicing, any of such disputes prior to filing of the application by the operational creditor. Now, in case there is a genuine dispute which has been raised by the defaulting Indian customer, the tribunal may dismiss the application filed by the supplier. In the recent past, there have been many frivolous disputes raised by the Indian corporate debtors once the operational creditor has initiated and filed an application seeking insolvency resolution of the debtor. The NCLT, the tribunal, has discarded such frivolous disputes and categorically stated that the disputes have to be genuine and should be raised prior to the operational creditor filing an application for commencing insolvency resolution process. And the last point in this slide is the fact that the IBC prescribes the time limitation for operational creditors to file an application for recovery of money, and that's 3 years. If an operational creditor has dues outstanding for a period of more than 3 years, the application is said to be time barred and may be dismissed by the tribunal.
Hi, so just to kind of dwell once more upon the point Arun had just very kindly made, before we move on to the next slide, we'd just like to emphasize once more the importance of not having a dispute. I mean, we cannot emphasize enough on this particular point because the entire enforcement regime under the IBC, the insolvency code vis-a-vis the operational creditor who wants to recover his dues, really hinges a lot on this one particular point. If you've supplied goods or services, you've raised an invoice, and if your customer has raised a dispute, then we would strongly advise you not to pursue this if there is a genuine dispute, because this is the single point on which the NCLT will not admit the claim. And therefore, it's of extreme importance that, and a dispute can be established by way of trail communications, by way of historic emails. And so therefore, this exercise needs to be done meticulously, that we go through the entire history of your records to establish that at no point was a dispute raised. Again, we emphasize the entire enforcement mechanism will crack and fall down if there is a pre-existing dispute with respect to the supply of goods or services. With that, I will pass it back to Arun to kind of take this further, and we'll come back on the Q&A if people have further questions on this point.
So we move on and discuss the process for recovery. The IBC prescribes certain processes as to what are the pre-filing steps to be taken by an operational creditor or a supplier to initiate the process of recovery. Now, the supplier is required to issue a statutory demand notice to the Indian customer. The Indian customer is bound to respond to such demand notice within a period of 10 days. If the reason why the Indian customer is given the chance is what Ajay just described. If at all there is a dispute which has and a genuine dispute which has been raised by the Indian customer prior to receipt of this demand notice, he might bring up the dispute again and notify the supplier of the fact that he had in fact raised a dispute prior to receipt of the demand notice, and also the fact that and also the fact that if yeah within.
So just again on this point again, what we had earlier discussed with respect to the dispute, as Arun was just mentioning, is the objective threshold. Now, this is the way the objective threshold has been prescribed under the IBC, is that you have to start the process by filing a statutory demand notice. Once the demand notice is sent, the corporate debtor, that is your customer in India who's defaulted, has 10 days to reply to the demand notice. Within 10 days, if he does not reply, you are entitled to initiate proceedings with the NCLT. Now, the entire dispute issue is of critical importance here again, is because the threshold timeline commences immediately upon receipt of the demand notice. So he cannot raise, your customer in India cannot raise a dispute after he's received the demand notice. That's really what the law is prescribed. That's really what the NCLTs or the tribunals in India have upheld multiple times. So let's take a situation. You send a statutory demand notice where on the 17th of July, you send it as of today to your defaulting customer in India. He has 10 days to reply, and he can raise a dispute which was existing, but that dispute should have existed before 17th of July. 17th of July is the date that he receives the demand notice. He should have raised, notified you about a dispute that existed before 17th of July. If he raises a dispute which he had never raised before 17th of July, the tribunals will not hold that dispute and will admit the matter if the claim is genuine. And that's why this timeline is really critical. It's extremely critical, and it's very important to remember. This is really the trigger point for you to enforce your recovery process. Back to Arun to continue on this.
Yeah. So the jurisdiction, we'll move on to the next part of the slide, the jurisdiction for filing claim. Each NCLT has its own geographically demarcated jurisdiction. The application has to be filed with the NCLT under whose jurisdiction the supplier's registered office falls. Along with the application, the supplier needs to file certain other documents, certain other prescribed documents with the tribunal, namely the records available with the information utility regarding the status and other basic details of the Indian customer's company, executed copy of the contract between the supplier and the Indian customer is as important. The invoice issued by the supplier demanding payment from the debtor company, a copy of the demand notice, the statutory demand notice which you had issued to the which you had issued to the Indian customer seeking a demand of money. And the last part is about appointment of IRP. Once the application is admitted, the tribunal will appoint an interim resolution professional to take over the company's management and formulate and preside over the insolvency resolution plan. For operational creditors, that is the foreign suppliers, it is not mandatory for you to prescribe the name of an interim resolution professional. An operational creditor may or may not. If you do not choose to nominate a professional for that, the NCLT, once your application is admitted, will propose an interim resolution professional to take care of the insolvency plan, and also the professional fees of such insolvency resolution professional has to be paid by the debtor company. Now, the last slide on this is what are the statutory costs involved in making such applications by operational creditors. Now, the statutory costs involved are really nominal. It's INR 2,000 rupees, which converts roughly to USD 30. And of course, there are no other significant costs apart from certain other minor nominal clerical charges that you have to pay with the tribunal. And the cost for advocates and other professionals do vary from each advocate from one advocate to the other. Yeah. So let's think about certain strategic considerations which you need to think of before you kind of think about entering into a dispute or entering into a litigation with your Indian counterparts. Now, while we never advocate to enter into litigation to our clients for very obvious reasons, however, in case a supplier intends to attack the debtor through litigation, they may need to look at various other strategic angles and determine the best method to approach the litigation. Uh, there could be many factors that you need to consider. What is the debtor's turnover? What is its assets, the net worth? These are all vital cogs in the strategy making device. Now, is the supplier's claim really significant vis-a-vis the debtor's net worth? Well, let's say, for instance, the supplier's outstanding receivables are $1 million and the debtor's net worth is 1.2 or $1.5 million. Is this going to be beneficial for the supplier to file claims and initiate an insolvency resolution process against such companies? What are the chances that the supplier will be able to receive all of its money post liquidation of the debtor company? There might be other defaults that the debtor might have committed, and like one supplier, that could be many other suppliers, banks, and financial institutions in line waiting to recover their monies, just like a supplier. Now, there may be other creditors standing in line, so this is another important aspect. If the supplier is dealing with a debtor who has a series of defaults, it may not be needed for the supplier actually to file an application. There are certain information, certain basic details about a company, their status, the financial health that can be determined, that can be known and ascertained from publicly available information. So we need to first consider: is this company already going certain liquidation processes? Are there other creditors who have filed applications and have got their applications admitted with the National Company Law Tribunal? If yes, all you need to do is file an application for claim with the insolvency resolution professional who has been nominated by the tribunal, and then stand in line to recover your dues. Also consider, what is your settlement strategy? Do you need to, are you thinking of recovering all 100% of your all your debts? This is something maybe Ajay wants to touch upon, so I'll request you,
Yeah,
please.
so thanks, Arun. Just wanted to kind of summarize on a whole as to the points that Arun was making. It really boils down to this principle. Merely because you have a strong case in theory doesn't mean that you actually will have one in practice. That's really the sum and essence of the strategic considerations. Now, this list that Arun took you through is not exhaustive by any means. It's meant to give you an indication of some of the things that we need to consider before you decide to engage into a litigation in India. Of course, it has its benefits over conventional litigation. It's very efficient, but there are many other factors that one must consider. Again, merely because there is a strong case in theory doesn't mean that it's a strong one in practice. For example, we've already discussed that Arun had said depending on the volumes of the claim and what is the net worth. Let's take a scenario where the outstanding payables that you have from an Indian client is in the range of $500,000. I'm not sure how that number works for most of you, but let's take for the sake of discussion $500,000. The net worth of your Indian client or your Indian customer who's defaulted is in the range of $10 million. Now, anyone with a commercial sense will tell you on this that if he's generally got a solvent business which has got a turnover or a net worth of about $10 million, as against an unpaid due of $500,000, no one would in their right mind risk their business worth $10 million for not paying a legitimate due of $500,000, especially when the regime for enforcement is fairly clear. Now, in the same scenario, if you've got a claim of $500,000 and the person's got a net worth of $10 million, but he's already defaulted on bank finance, which he owes to other lending institutions worth about maybe let's $7 to $8 million, the chances are you really don't have a good case to go against this particular defaulter, because the banks will in any case file against him. And even if you were to file, you would have to stand below the banks in the priority of claims, because the banks are financial creditors. You would still be an operational creditor. So in the priority of claims, you would be lower. Therefore, while in theory you may have a good case, in practice, it's still not a good case to file. But let's take another situation in the same scenario. $500,000 of your receivables that you need to receive from the Indian client. got a net worth of about 10 million or a turnover of about $10 million. He's got bank finance of about $5 million. The important point here is he's not defaulted on the bank finance. He's servicing his bank debt properly and in timely manner. Still a great case for you to file because a bank which has lent him $5 million would never let the company go down south. Again, this gives you a lot of leverage to kind of strategize and figure out. Now, a lot of this information can be pulled out from the public domains and with a bit of diligence about your corporate debtor in India. And it will allow you to formulate, along with your lawyers, a very good strategy to decide which are the correct levers to push in order to get your settlement. And as Arun earlier mentioned during the presentation, as corporate transactional lawyers and who do disputes, we would never advise our clients to jump headlong into litigation. The first strategy for any commercial dispute, at least what we look at from an Indian perspective, is to settle it. The IBC, with respect to operational creditors such as yourself, gives you an excellent forum to try and compel your corporate debtor, that is your defaulting customer, into a settlement. And every step must really be geared towards that. And because of the efficacy of this regime, you will have a situation depending on the fact pattern of your corporate debtor to drive that settlement to even 100% of your written off debts, to up to maybe 75%. You could also insist on recovery of all costs involved, all your legal fees involved. So there are various ways that you can kind of really work this settlement. But the most important thing to remember is that the Insolvency and Bankruptcy Code, the IBC, gives you an extremely potent leverage in order to recover your unpaid dues. Arun, over to you again. Just to what do we? Okay, so in conclusion, what we'd really like to say is that the IBC is an empowering tool for suppliers, not only foreign suppliers but also domestic suppliers. We're already seeing the green shoots of this, and we're very happy to notice this with our own clients as well, that they've all become far more disciplined in taking care of vendor payments, and that includes us, sleazy lawyers as well. So we also are quite happy with the way this works. It ensures a much better cash flow discipline across businesses. So the cash flow is less likely to get stuck within various avenues of the system. So just to quickly summarize before we conclude the presentation is, where do international trade suppliers stand in the scheme of the Insolvency and the Bankruptcy Code? You would be classified as operational creditors. You need to have unpaid dues, which are in excess of INR 100,000, which is give or take $1,500. There should have been no dispute raised with respect to your dues or the supply of your goods or services. Again, as we mentioned earlier, it's extremely important for you to ensure that. Thirdly, your debts should not be beyond 3 years from the time you file your claim. You should have sufficient evidence in terms of invoices, acknowledged emails, a contract with your corporate debtor, and then you must ensure what is the information you have with respect to your corporate debtor or your defaulting customer in India, so you can formulate an efficient strategy to recover your money. I mean, that's really what this boils down to eventually, to help you recover your dues from delinquent customers. And we've taken great risks to have actually made this presentation for the fear of being categorized as turncoats by our clients, but we've put our lives at stake here. A very quick snapshot about us. We're essentially an M&A and transactional practice which does commercial disputes. What that really allows us to do is it allows us to look at the business side of things very well. We understand the way businesses work. We understand the exigencies of business. And we know for a fact that commercial enterprises do not like to engage in litigation. And therefore, the sole focus of any commercial dispute is always to drive the settlement. And that's really the role that we play in this kind of a transaction, is to assess the merits of your claim, to help you strategize how to go about this, obviously represent you before the courts, and finally negotiate your settlement and do the drafting and the file documentation. Ron, I think that's it from me and Arun on the presentation. We're happy to kind of take in questions and reply to any queries.
All right, thank you so much for that very informative presentation. So if you have any questions, you can now type in your questions to the chat box. so that the presenter can answer the question for you. Anyway, if you can see here, all the contact information of our presenter is here. So if you would like to ask more specific question or is it that you're currently experiencing, you can contact them directly, and you can also contact International Trade Council. So I'm just waiting if there is a question in the chat box. Give me 1 second here.
Sure.
Thank you. Mhm. And by the way, while we are waiting, I just want to inform you that you can all, if you would like to be a member of International Trade Council, you can just go to our website. Just type in International Trade Council. That is the first result in Google, and then you have an option there to be a member. And if you would like to know more information about it, just send us an email. So I'm just waiting for if there are some people who would like to ask questions. And again, this presentation is recorded. If you would like to get a copy, just let us know, and we will also send the presentation to all the registrants. Even though some other registrants did not attend, we will definitely send them this presentation as well. So some people are still typing in.
Oh, great. We thought we made an amazing presentation. There's no questions at all.
Let's see. There you go. There's one question here.
So we'll just read out the question and then we will reply. Can you please advise us the best way to protect yourself, company as supplier in terms of documentations and paperwork? Of course, obviously, we will not be able to give you an exhaustive response because the documentation is something that needs to get drafted and reviewed and vetted. But of course, some of the things that you'd really want to ensure in your documentation, hopefully, is to be absolutely very clear on the repayment timelines. Don't leave it open in your documentation at what point of time is the supply, post the supply of the goods or services, are you supposed to recover your payments. So let's take, for example, rather than saying that from the time they receive the goods, they will confirm that everything is okay. Try and make the repayment timeline as objective as possible. To maybe say 15 days from the date you put the shipment away from your hands. Uh, I mean, that's just an example, but you'd want to ensure that the due date for repayment is as objective as possible. That's one thing that you definitely want to kind of build in. You would definitely want to build in provisions with respect to raising of any dispute with respect to the goods or services supplied. Of course, if there is a genuine dispute and they've raised it, they will always have the ability to raise that when we initiate the claim. But within your documentation, you might want to try and put in a process which is objective again, within which a dispute can be raised, beyond which it will be deemed that the goods or the services are accepted without any demur, that is, without any issues from the end of the customer. Those are two of the points from an IBC perspective or an insolvency recovery perspective that we would certainly advise clients to kind of ensure in their documents. Another thing that really comes to our mind is, at least we noticed this from domestic businesses, is to be very clear about the email communications after you have a contract, because in majority of the cases with respect to operational creditors that we see before the tribunal, beyond the contract, what we really see is emails which demonstrate either that a dispute has been raised or the contract itself has been amended. So this is an advice that we always tell our clients: be very careful about the emails that you exchange. That they should not in any way amend the existing contracts that you have with your customers. I hope that kind of replies. Okay, great. They've thanked us for the
Oh,
advice. Thanks, Mohammed, for
okay.
the question.
All right. Do you have Is there any other questions? Okay, I think everything is clear. So again, the information of the presenter is on this page. And if you would like to, well, we will be sending this presentation anyway. So thank you so much for your time today. Well, we hope that you get more information about the topic, and if you would like to reach them, you can contact them directly. So you all have a wonderful day, and thank you so much.
Thank you, Ron. Thank you, ladies and gentlemen, who have joined us. Thank you.
Thanks.
Bye.